have a lot of issues that we're going to be analyzing this afternoon. One of the issues is the fact that next week, alternative dispute resolution practitioners, paralegals, academia, lawyers, and other stakeholders will gather in Accra for their 5th annual conference. And this year's conference is under the theme Alternative Dispute Resolution, a complement to quality justice delivery. Let's get full understanding of what the conference is about. And Isaac Asare is the administrator of the Ghana National Association of ADR Practitioners. He joins me in the studio. Good afternoon to you, Isaac.
Good afternoon.
Very refreshing to see you here.
Thank you.
So why are we calling for ADR now? Why has it become so necessary now?
Okay, thank you very much. As the word is emerging in Ghana as an emerging country, and we are inviting a lot of investors and businesses growing, we need systems that will help them to resolve their disputes when one arises, so that they will be able to cut some losses and other things. You know, litigation takes a lot of time, and we don't know when a litigation can end at the court. But ADR is flexible, it's cost effective, and the parties have their own way of managing the conflict. That is why we are calling for ADR now, and for the full implementation of the Act 798 of 2010. So that people
we know that there's congestion at the court. I'm talking about a lot of cases lined up to be dealt with, and you rightly said you don't know when a case will end, so you can get justice. But let's look at what the situation is currently and the reason why we need ADR to complement the justice system.
Thank you. This is how the situation is. In 2010, the Act 798 of 2010 was passed, which is the ADR Act. So the Minister of Justice and the Attorney General is to see to the full implementation of the ADR Act by establishing what we call the National ADR Center, which, if you look at the section 114 of the Act. So the center will regulate the practice of the ADR in the country. But as of now, the center has not seen the light. But while the government sector is failing to establish the center, the private sector have to take it up. So that is why the Ghana National Association of ADR Practitioners was born, so that we can also bring our members together to also enhance their practice, so that they can also help the disputing parties out there, so that they can have a fast way of resolving their dispute, and not necessarily go into the courts. Although the court has a full directorate for ADR at the courts, but you cannot go to the court and report your case to be settled by ADR unless you have filed a case at the court. So if you want to use ADR outside the courts, so that is why an association of ADR practitioners, our members are in town, so that they can also assist people to resolve conflict rather than going to the courts.
Okay, we know that it's been around for some time now, especially when the Chief Justice introduced this whole initiative, and the aim was to also help to reduce the congestion at the courts. But we know that a lot of people haven't opted for this. What should we expect now that we are championing the cause to make it happen and ensure that it reduces the burden on the the normal court system?
Thank you. It's because a lot of people do not understand what the efficacy of ADR. They don't understand, and there needs to be more education on ADR, because in ADR, if it is mediation, it is the parties who are the owners of the issue, and they are able to talk, and they are able to express their feelings and what they need, their interest in the case. But in the courts, you only show evidence for it to be determined by somebody. But ADR is different. So that is why a lot of people need to understand it, so that they can take advantage of ADR. Because if you are having a dispute with a business partner, do you want to expose your trade secret at the court? Court is public, and anybody can be sitting there to watch. So ADR have come so that they can protect people to resolve their conflict through confidential process, so that people can understand and work without any adversarial way. So that is how ADR works.
You've rightly pointed out that people don't understand what it stands for, and that's why probably they are not opting for it. What do you intend to do as an association to ensure that people get to understand what's going on, so they can understand that ADR is even more efficient than going through the normal procedure, because it takes a longer time?
Thank you very much, and that is why you have invited here today, and which is good. Thank you very much. What we do every year is that the first Friday before our conference every year, we organize what we call public sensitization program, and this year we are organizing it on 11th May. We focus more on, this year we'll be focused on taxi drivers, especially those who enter in work and pay. you will see that there is no dispute resolution clause in their contracts. And some of them, the contracts are such a way that the taxi drivers do not benefit from it. So we have taken that initiative that this year we are going to focus more on the taxi drivers so that we'll be able to help them understand what they are going into it, and also they can also help to draft their contracts so that they can include ADR clause. Because when you look at the system now, any proper contract must have alternative dispute resolution clause, which will underpin them that when there is a dispute, these are the ways that you can use to resolve the matter. Okay. So that is how ADR works, and that is what NAP seeks to champion, so that a lot of people will be aware of what is happening in ADR and what ADR can help them to do.
So just by way of education, and I think we've started education right now, can you explain to us exactly what ADR means so that even the ordinary Ghanaian can resonate with? We know there is mediation, we know there is negotiation. I mean, exactly what does ADR stand for?
Thank you. When you say ADR, ADR simply means alternative dispute resolution, a way of settling disputes rather than using the normal litigation system. So like you said earlier, you can use mediation. Mediation is where the parties is being assisted by a third party neutral called a mediator. That is mediation. It is the parties who will talk. The mediator role is to just facilitate the process for a resolution. Then we have a negotiation. Negotiation is the two people who are in conflict. They will meet and discuss their matter and resolve it without a third party.
No third party.
Yes, there is no third party. Then we have arbitration.
Yes.
Arbitration is where it's like renting a judge. This one, you go to the court. You see somebody, you submit all the evidences and all the claims to the person. The person will look at the issues and compare with the laws and determine the issue. The person will give judgment. So because the judgment is not given by the court, it's given by a private person, we call it an award, an arbitral award. So that is what arbitrators do. Then we have case determination. Like if you remember in 2012, when the NPP and NDC were litigating at the court, they used an ADR method whereby they call KPMG to come in and determine the number of the pink sheet and other things. These are all ADR mechanisms that are used to augment the court system. So that is how it is. And every ADR issue or the outcome of any ADR process, it is binding and it is enforceable as well.
And so we're talking about mediation, negotiation, arbitration. And in the event where you have to bring in an arbitrator, it means that you have to pay the arbitrator, or is it for free? And that is where probably people may start stepping back, because it also is cost intensive and people may not have the money to do that.
Sure. For instance, when you want to pick a mediator, it is not for free. You have to pay. But when you compare paying the mediator and going to the court, if you compare the two, you will see that the ADR process is faster and is cost effective than using the court. ADR mediation can use only 2 sittings and give, and the parties will be able to resolve the matter. But the court, you don't know when the outcome will come, and you don't know when you're going to get the judgment. And in arbitration, you can give yourself a time. Arbitration does not take more than 3 months, or certain instances 6 months. So all the rules. That is why in mediation, when you are starting a new mediation, we have something that we call consent to mediate. You sign the consent to mediate to indicate your commitment to the process and the number of days that you want to use to resolve the matter. Arbitration also follow the same rules. We have instead of mediation is consent to mediate, arbitration is arbitral rules. So that is the rules that is underpinning the arbitration process. So you sign arbitral rules so that you know that this arbitration, this is what we are going to do. All our evidences are going to be given orally. So those are the things that you do in arbitration, like what happened between Ghana and Cote d'Ivoire, the 8 loss issue. It did not take much longer time like a court would have done. Those are the things that ADR makes it cost effective. And ADR is very effective. You can go 1-2 sittings, even 1 sitting can resolve a matter. But courts, even to file the processes and other things, will take a longer period. And when you go, it is adversarial. But ADR also try to bring the parties back together, for instance, in mediation. It repairs relationship, and the parties are able to know certain things, because when you give them the opportunity to talk, they are able to express their feelings and what is important to them. So that is how they are.
I think one of the concerns that have been raised over the years has been the fact that because it is not a court settlement, it's a kind of out of court settlement, people may agree that, okay, I have to, if it's, for instance, you're arguing over money or something and it's settled at the mediation level or arbitration level, and one of you is asked to pay the other an amount of money, the person may decide not to pay on time, as in a court issuing an order and telling you to do ABC. Who monitors that? The other party or whoever is responsible for making this arbitration easier does it so that everybody will have some peace?
Yeah, that's a good question. One thing that happens in ADR protests is that the moment the outcome is made or the parties agree to sign, if it is mediation, the moment you get a terms of settlement, it is binding on all the parties.
Yes.
So once somebody fails to honor their part of the agreement, the other party only have to go to court with motion for enforcement, for adoption and enforcement, so that they can be enforced as court judgment the same way.
Wouldn't that also be another stress, because you went to arbitration, negotiation or mediation because you wanted to stay away from court, but if you would have to go back to court to ensure that whatever happened at that level now is enforced at the law court, then it becomes another stressful process.
This is what makes it easier. When you go to the court for the enforcement, it doesn't take longer time like the normal court process will do.
Okay.
If all the processes that you have to file for motion, the day that the judge will sit on the case, they can give determination on that day for adoption and enforcement. Even on just one sitting or two, the judge can give a determination on that. It's not like the normal court process.
Okay, but that comes with an extra cost.
That comes with a cost, but it will not be huge like the other court processes that you'll be going. The normal court. So this one is a little bit different from the normal way. It's like you have secured a judgment at the court and you are going for enforcement the same way. Right. Just that this one you file for a motion for adoption and enforcement.
Okay, so what's the plan with your association? What's the plan like? What's the strategy to get a lot of people to embrace this ADR, knowing that it's more efficient?
Yes, as I related the idea, we are educating more people, and before our conferences we meet the public, like we are doing radio sensitization, TV and other things to get people informed that yes, ADR is the best way to go. Although you cannot use ADR to resolve all issues.
All the issues.
Yes, but in most civil cases, especially business disputes, family, tenancy and other disputes can be resolved using the ADR process, and people should be able to embrace it. In the workplace, if you go to, today is Workers' Day, let me say happy Workers' Day to all the workers. When you go to the National Labour Commission, who is responsible, or the agents responsible for managing workers' conflicts, when you go, the process that they use is ADR processes. They use arbitration. When you look at their acts, the Labour Act, the 2003 Labour Act, they use ADR process, and to resolve it at the Labour Commission, they have a list of mediators, they have a list of facilitators, a list of arbitrators that they use. And when people have issues, they should go to the Labour Commission, especially the workers. They don't know where to go. Some of them will be roaming about. Every worker in the country is mandated, when they have issues, they can go to National Labour Commission. And the process that they use there is ADR, and it's enforceable. Or you can see any ADR practitioner or ADR center. There are a couple of few centers in the country that you can go report your issue. They will also get back to the company, and they will be able to help you out. If the matter cannot be resolved there, they will be able to tell you that, okay, this matter, because of ABC, it cannot be resolved there, so you have to take this step or do this or that. Those are the things.
All right. Many thanks to you. Isaac Asare is the administrator of the Ghana National Association of ADR Practitioners, and he is saying that we will all enjoy it if we decide to go the ADR way. But if you go and it is not something to be resolved on the ADR level, you can be referred to go through the normal court procedure. Many thanks for your time. We really appreciate your time. We'll take a break on the pulse, and when we come back, Joy FM is 23 years. How has the journey been so far? We'll be telling you about all the challenges and the successes chalked so far.